Difference between contract of indemnity and number of parties. Guarantee. Contract of guarantee involves three parties: the creditor, the principal debtor, and the guarantor. Contract of indemnity involves the parties: the indemnifier and the indemnity holder. Nature of liability. Guarantee. The guarantor's liability is secondary and contingent upon the principal debtor's default. Indemnity. The indemnifier's liability is primary and arises as soon as the indemnity holder suffers a loss. Purpose. Guarantee. To assure the creditor that the debt or obligation will be paid even if the principal debtor defaults. Indemnity. To compensate the indemnity holder for losses or damages directly, regardless of third-party actions. Scope. Guarantee. Typically specific to a particular debt or obligation. Indemnity. Can cover a broad range of potential losses or damages as defined in the contract. Right to sue. Guarantee. The creditor must first attempt to recover from the principal debtor before claiming from the guarantor. Indemnity. The indemnity holder can directly claim compensation from the indemnifier as soon as the loss occurs. Trigger for liability. Guarantee. Liability is triggered by the principal debtor's default. Indemnity. Liability is triggered by the occurrence of loss or damage. Subrogation rights. Guarantee. The guarantor, upon paying the debt, steps into the shoes of the creditor to recover the amount from the principal debtor. Indemnity. The indemnifier may have rights of subrogation to recover the amount from any third party responsible for the loss after compensating the indemnity holder. Consideration. Guarantee. Consideration flows from the creditor to the principal debtor, and the guarantor's promise supports this transaction. Indemnity. Consideration is typically given by the indemnity holder to the indemnifier for the promise of compensation. Asterisk. Existence of primary liability. Guarantee. There is always a primary liability on the principal debtor. Indemnity. There is no primary liability on any third party. The indemnifier directly compensates the indemnity holder. Nature of promise. Guarantee. The guarantor makes a promise to the creditor to fulfill the principal debtor's obligation if the debtor defaults. Indemnity. The indemnifier promises to compensate the indemnity holder for losses regardless of any third party's default. Legal actions. Guarantee. The creditor must first pursue legal action against the principal debtor before the guarantor. Indemnity. The indemnity holder can directly pursue legal action against the indemnifier without needing to address third parties. Extent of liability. Guarantee. The guarantor's liability is limited to the extent of the principal debtor's obligation. Indemnity. The indemnifier's liability is typically broader and can include all defined losses or damages. Reimbursement rights. Guarantee. The guarantor can seek reimbursement from the principal debtor after fulfilling the obligation. Indemnity. The indemnifier may seek reimbursement from any responsible third party for compensating the indemnity holder. Independence of obligation. Guarantee. The guarantor's obligation is dependent on the principal debtor's obligation. Indemnity. The indemnifier's obligation is independent and arises directly upon the indemnity holder's loss. Legal definition and framework. Guarantee. Defined under specific statutes and laws related to guarantees, often with specific formalities required for enforcement. Indemnity. Defined under broader contract law principles, focusing on compensating for losses.